Everyone, please stand.
All right. Oh,
Please stand. You all may be seated. Let the record reflect that we're back in session in cause number 328, 325, case of South State of Texas versus Cody James Patterson. Let the record reflect that Mr. Patterson is present in court with his attorney Wright Kimler. State is present with Assistant District Attorney Lamar Johnson, and Attorney Tommy Coleman. Let the record also reflect that the jury is now present in the courtroom. The state, prior to taking a break, the state rested. Is that correct, Mr. Coleman?
yes, sir.
Mr. Kimler, you may go forward.
Your Honor, at this time, we would offer defense exhibit 2, the poster there for the diagram. No objection, Judge.
Okay, no objections, and that's defense exhibit what?
2.
2, okay. Defense exhibit number 2 will be admitted. Mr. Kimler,
Then we re-urge our previous motion made at the close of the state's case.
oh, okay, that motion has been overruled.
And then we rest.
Okay. Ladies and gentlemen of the jury, both the state and the defense has rested. The court has prepared a charge. We've had a charge conference while you were also in the hallway. And so the court is going to read its charge. And once the court finishes reading the court's charge, then the state and the defense will present their closing arguments. Members of the jury, the defendant Cody James Patterson stands charged by information with the offense of being intoxicated while driving or operating a motor vehicle in a public place, and the analysis of a specimen of the defendant's blood showed an alcohol concentration level of 0.15 or more at the time the analysis was performed. The offense is alleged to have occurred on or about the 3rd day of October of 2020 in Jefferson County, Texas. Defendant has entered a plea of not guilty. Our law provides that a person commits an offense if the person is intoxicated while driving or operating a motor vehicle in a public place. A person is deemed to be intoxicated within the meaning of the law when such person does not have the normal use of physical or mental faculties by reason of introduction of alcohol, a controlled substance, a drug, a dangerous drug, or a combination of at least 2 of these substances, or any other substance into the body, or having an alcohol concentration level of 0.08 or more. A public place means any place to which the public or a substantial group of the public has access and includes but is not limited to streets, highways, and the common areas of the schools, hospitals, apartment houses, office buildings, transport facilities, and shops. Now, bearing in mind the foregoing instruction, if you unanimously find from the evidence beyond a reasonable doubt that on or about 3rd day of October 2020 in Jefferson County, Texas, the defendant Cody James Patterson did then and there operate a motor vehicle in a public place while the said defendant was intoxicated, and that the analysis of a specimen of the defendant's blood showed an alcohol concentration level of 0.15 or more at the time of the analysis was performed, then you will find the defendant guilty as charged. Unless you do so find beyond a reasonable doubt, or if you have a reasonable doubt thereof, you will next consider whether the defendant is guilty of the lesser included offense of driving while intoxicated. Now, bearing in mind the foregoing instructions, if you unanimously find from the evidence beyond a reasonable doubt that on or about the 3rd day of October of 2020 in Jefferson County, Texas, the defendant Cody James Patterson did then and there operate a motor vehicle in a public place while the said defendant was intoxicated, then you will find the defendant guilty of driving while intoxicated, unless you do so find beyond a reasonable doubt, or if you have a reasonable doubt thereof, you will acquit the defendant and say by your verdict, not guilty. General instructions. All persons are presumed to be innocent, and no person may be convicted of an offense unless each element of the offense is proved beyond a reasonable doubt. The fact that a person has been arrested, confined, or indicted for, or otherwise charged with the offense gives rise to no inference of guilt at the trial. The law does not require a defendant to prove innocence or produce any evidence at all. The presumption of innocence alone is sufficient to acquit the defendant unless the jurors are satisfied beyond a reasonable doubt of the defendant's guilt after careful and impartial consideration of all the evidence in the case. The prosecution has the burden of proving the defendant guilty, and it must do so by proving each and every element of the offense charged beyond a reasonable doubt. And if it fails to do so, you must acquit the defendant. It is not required that the prosecution prove guilt beyond all possible doubt. It is required that the prosecution's proof excludes all reasonable doubt concerning the defendant's guilt. You have a right to consider all the facts that are shown by the evidence to draw natural and reasonable inferences from such facts. You alone have the authority and duty to determine what the facts are. In evaluating the evidence, you must totally disregard what you believe is my opinion about any factual matter. You cannot question the bailiff concerning the testimony or the law, nor should you discuss the case in his presence. If any question develops during your deliberation, it must be reduced to writing, signed by your foreperson, and given to the bailiff. The question will then be answered by the court as soon as possible to the extent allowed by the law. Questions or comments of the attorneys do not constitute testimony and must not be considered as evidence. You must also disregard any statement of the attorneys that is inconsistent with the law contained in this charge. Any physical exhibits admitted into evidence will be furnished to you by the bailiff upon your request. You must not consider facts that have not been introduced into evidence or legal principles not contained in this charge. It is improper for you to discuss or consider anything which you know or have learned outside of the testimony presented to you and the law contained in this charge. If you should discover that you have any outside information, you should not mention this information to any other juror, nor consider it yourself in arriving at a verdict. Our law provides that a defendant may testify on their own behalf if he elects to do so. This, however, is a privilege accorded to the defendant, and in the event he elects not to testify, that fact cannot be taken as a circumstance against him. In this case, the defendant has elected not to testify, and you are instructed that you cannot and must not refer or allude to that fact throughout your deliberation or take into consideration for any purpose whatsoever as a circumstance against the defendant. You are the exclusive judges of the facts proven, the believability of the witnesses, and the weight to be given their testimony. However, you must be bound and strictly follow the law contained in this charge. Your failure to follow the law could result in a mistrial being declared, and your deliberate violation of this charge could submit you to being held in contempt of court. After the attorneys present their argument, you will retire, select a foreperson, and consider your verdict. The arguments are not evidence, and you should give the argument only the consideration you feel they deserve during the evaluation of the evidence. It is the duty of your foreperson to make certain that your deliberations are conducted in accordance with this charge. After you have reached a unanimous decision, your foreperson should sign the appropriate verdict attached to the charge. In returning your verdict, it is your responsibility to make certain that justice is done in this case. And attached to this charge is a verdict page. At the top, it reads, "We, the jury, find the defendant not guilty." If that is your verdict, then your foreperson will sign on the top line. Or, "We, the jury, find the defendant guilty of driving while intoxicated and blood showed an alcohol concentration level of 0.15 or more at the time the analysis was performed." If that's your verdict, then you will sign, the foreperson will sign on the second line. Or, "We, the jury, find the defendant guilty of the lesser included driving while intoxicated." And if that is your verdict, then you will sign, the foreperson will sign on the bottom line. Do you understand? Okay. State, are you ready?
Yes, Your Honor, at this time, state will waive its right to open, but reserve its right to vote.
The defense, are you ready?
Yes, Your Honor.
Okay, Mr. Kimbler,
2 minutes, Your Honor.
yes, that's, the court will give you 10 minutes.
I'll be sure.
Yeah, you can turn that around.
Ladies and gentlemen, thank you for paying attention to the case. State, I'm sure takes this very seriously, as does Mr. Pius and myself, so your attention, the fact that you showed up for jury duty, also appreciate it. Judge Holmes just instructed you that shortly you're going to go back into the jury room, begin your deliberations, and it's your obligation or duty to see that justice is done. I'd simply suggest that you consider that that's not a collective responsibility that you all have, it's each an individual responsibility that you bear to see that justice is done. What I mean by that is there's not some type of obligation imposed on you to return a unanimous decision. And so if you go back and after good faith deliberations between yourselves, you find yourselves unable to come to a unanimous decision, that's not some sort of failure on your obligation or duty to see the justice is done. It just means that we have a disagreement, carry to resolution, and we come back on a different day with another jury to see if there could be a unanimous decision, either guilty or not, either way. I would suggest to you again that the only way that you violate your duty back there to see if justice is done, that form of deliberation is one or more of you give up if you think was the correct decision, the correct vote, simply return it. There's nothing wrong, again, as I said, with not being able to agree. Well, the issue would be that if you give up what you think is the correct decision, the correct vote, simply to return a vote. So having said that, looking at this case, again, the prosecution, a lot of times in their argument will say, well, you don't leave your reason and common sense at the door when you go back into the jury. You take that with you. And I encourage that, because I think that's an accurate statement. We're looking at the evidence in this case. Now, particularly, I'll begin with the allegation of the 0.15 or above. In this particular case, the state is elected to pursue the greater offense in Class A misdemeanor, driving while intoxicated with blood analysis of a 0.15 or more per 100 milliliters of blood, alcohol per blood. And they presented evidence in that regard, both regarding the blood draw itself and the analysis that was conducted, and presented evidence that this result was a 0.3, 0.06 or whatever it was, 0.3 basically. Ladies and gentlemen, that's an extremely high, that's extremely high blood alcohol concentration, 0.3. When you consider the fact that 0.08 is the legal cutoff for DWIs. So we're talking about almost 4 times the legal limit. Again, as I said, on your reasoning, common sense, I'm sure each of you may have had experience either personally or with other people that have been under the influence of alcohol. But that level of intoxication would carry with it observable physical and mental effects that you would expect from someone with that degree, if that indeed is an accurate analysis, that you would expect to see in an individual that has that level of alcohol in their system. I would suggest to you, first of all, that this analysis that was conducted is actually inaccurate to call it an analysis of blood, because what it actually is an analysis of, first of all, gas, but gas that is emitted from a superheated combination of human blood and at least 4 other chemicals. But actually what's being analyzed or run through this machine is a product of a scientific process or a chemical process that isn't actually analyzing the blood, but analyzing gas emitting from a solution of blood and 4 other chemicals. You can take that for what it's worth, but it's again inaccurate based on the facts to say that that's an analysis of Mr. Patterson's blood. It's not. And now the analyst was able to tell you the basic mechanics of how she carries out the procedures, run these in batches of 30, that somehow after she's prepared this and that the machine collects this gas, that it's run through this machine and it spits out a result at the end, a numeric result that then the state prosecution brings into court and presents to you as legally sufficient, legally significant evidence of someone's guilt. It's something that should be held against them and as a consequence potentially be convicted and punished without really providing an explanation of how that number is generated within this device, the machine, whatever you may call it. You can take that again for what it's worth. You're the sole judge of the facts in this case. You're the sole judge of the credibility of the witnesses, what to believe. All part of what you're going to take, including the lie. If you think that somebody's freedom should rely on something more than these cold results of some sort of inexplicable mechanical operations of this machine, then I suggest to you that that's reasonable doubt. And again, you'll look in the court's instructions that he gave, and you can have a copy of it in the back that was spoke about in board hour. Reasonable doubt's not defined. So when you go back and you start your deliberations, looking at the state's evidence as it's presented, each of you should fix in your own minds, I have a standard proof beyond a reasonable doubt. What is it? We discuss that briefly in board hour. Hopefully when you go back into the jury room, you'll have fixed in your mind the standard of proof reasonable doubt is, what that means to each of you. You could have six different conceptions of proof beyond a reasonable doubt when you back there. Not one of you will be wrong. All of you will be correct. Your own individual subjective determination of what a high standard of proof is. When you evaluate the lab analyst, whether this is a 0.15 or above, whether it's a 0.13 is accurate, looking at the observable facts of Mr. Patterson on the tape and how he's reacting and interacting with S.A. Hargrave. Again, reasonable doubt. How difficult of a standard that is when you're looking at what the facts are, evaluating them when deciding whether or not Mr. Patterson should be convicted. So I'm sure each of you will hold the statement about how burden to prove that. Now, as I said, you have this 0.3 result that's been presented to you. If you can believe, not believe, whatever you determine, and applying the proof beyond reasonable doubt standard, whatever determination you want to make. But I would suggest that that's not occurring in a vacuum, so to speak. Looking at a 0.3, you can go back and look at the way Mr. Patterson on the tape was interacting with the truth. Does he appear to have mental coherence? Does he appear to have proper cognitive functioning? Again, I go back again to what I questioned the trooper about. If you're asking somebody for consent to draw blood, you're asking for their consent, and a consent that has very, very significant legal ramifications, significance in court, the use of the blood draw, very significant consequences, then that consent, as the officer is attempting to elicit, presupposes proper cognitive functioning, or at least sufficient cognitive functioning to exercise effective consent. Consent that has legal significance that will be held to be sufficient to allow the blood test results to be admitted. In other words, when the officer, and she read through the DIC 24 and all the information the person is supposed to understand and comprehend, when she asked for that consent, she really was making the admission that he had mental clarity, he had sufficient mental function, he had the normal use of the mental and physical faculties to exercise effective consent where she could draw the blood. And I suppose the state seeks to have it both ways when they tell you, well, no, he doesn't have normal use of his mental faculties because of the introduction of alcohol, but he had sufficient mental faculties, normal use of mental faculties to execute proper consent. Again, looking at that from the standpoint of reason and common sense, you can see the contradictions in that. But on the one hand, the state wants you to believe that he had sufficient mental capacity. On the other hand, they tell you that he doesn't. So which is, and again, you can consider that. You can consider the fact also, I suppose, in looking at Mr. Patterson's physical attributes at the time of the stop. We don't see any of the other field sobriety tests because of the accident, which I would suggest to you from the photographs, looks like a rather severe collision. But you don't have the other two components of the standardized field sobriety test, looking away from just the blood test. So you're just looking at, how did he look? You can infer intoxication from his thinking, slurred speech, his physical attributes, those types of things. If you want to look at intoxication, whether they proved it from those aspects. You don't get to see him perform the walk and turn. You don't get to see him perform a one-leg stand. Again, that's not something that should be held against Mr. Patterson. That's should be held against the state as a deficiency in their proof. But that evidence isn't before you, whether you can see how he performed physically because of the nature of the accident. What you have, as far apart from the blood test, is simply this horizontal gaze of status as the first component of the triad of the standardized field sobriety, where there's an examination of how your eyes track and move, whether there's involuntary movement. And I would suggest to you, and again, I think this comports with the law, that the horizontal gaze of stagnance test in and of itself does not establish intoxication. It's simply a method by which you can tell if a person has ingested some alcohol or something in the presence of alcohol, but not necessarily intoxication. So really, apart from Mr. Patterson's admission that he had ingested alcohol and the HDN test, the only thing that the state has to show intoxication is this blood test. So if you ask yourselves, is it sufficient for each of you in looking at one of your fellow citizens to convict them based upon this high analysis of a compound that's not even their blood anymore, and it's gas in there? If that establishes truth beyond a reasonable doubt, then for your standards, there should be a conviction. If you do have a reason about that, whether that's sufficient, then your verdict should be not guilty. And I would suggest to you, looking at this case in the totality of the circumstances, looking at that blood test analysis, that analysis does not comport with the way Mr. Patterson appeared on the video, the way he interacted with the officer, his mental state, and everything else. And so the verdict should be not guilty. And I suppose the state may make the argument to you, well, maybe he's just a practice drunk, and he's used to ingesting alcohol. There's been absolutely no evidence. That's speculation. And that there was some testimony from the lab analysts that some people handle alcohol better than others. But again, I go back to a 0.3 being over 4 times a minute. It's hard to believe. It's hard to conceive that there wouldn't be more indications of intoxication on Mr. Patterson's part if that level was accurate. We know that normally when he goes to the lab, it's refrigerated. For whatever reason, when it's collected from the DPS offices, it's not refrigerated. It's not refrigerated in transport. There's just not enough known to convict based upon that lab test result. And I'm not criticizing Ms. Parker or anything. She does her job. She does what she's told. But there's a dearth in her knowledge about really how that mechanism, how she can explain to you this 0.3 and translate that into evidence sufficient to potentially deprive somebody of their freedom for a year. And that's reasonable. And I ask that you return back.
Okay, Mr. Kimler, you took, give you 12 minutes,
I'm sorry.
21 seconds, nice, right?
We ask you to stop, Judge.
Mhm.
That's fine.
Yeah, yeah, you'll have equal time.
See,
Okay.
good afternoon, may it please the court.
Yes.
First of all, and Mr. Kimmer, good afternoon, ladies and gentlemen of the jury. On behalf of the district attorney's office, I want to thank you for your time and attention during this case. From time to time, I looked over, glanced over it, and I do believe that you've given this case sufficient attention throughout this trial. Although albeit a brief trial, I believe that you've given it sufficient attention. I'll start by saying you do not have to memorize everything the judge read to you in the jury charge. You will have an opportunity to take a copy back there with you. You can use it, refer to it, and use it as a guide throughout your deliberation. And I also want to say that Mr. Patterson is not on trial to determine whether or not he's a good person or a bad person. Okay? He's on trial for driving intoxicated. I've heard it said that good people make poor choices. I submit to you that in this case, Mr. Patterson, back on October 3rd, 2020, made a poor choice. He consumed alcohol and got behind the wheel of a motor vehicle. And I take issue with the fact that Mr. Kim says all we have here to prove evidence of intoxication is the blood alcohol analysis. No, we have an accident. We have a motor vehicle accident, which could have been a lot worse. Which we could have been dealing with more than a misdemeanor. Thank God we're not dealing with more serious alcohol. So I take issue with the fact that all we have here is the blood alcohol concentration or the analysis. You know, this is what our system is about. You know, bringing you guys in here and testing our evidence, and with the assistance of formidable counsel, capable counsel, cross-examining our witnesses and taking us to task, taking the state to task and holding us to our burden. And I submit to you, have met our burden, and the burden of proof beyond a reasonable doubt. I submit to you that given the evidence in this case, there is no other reasonable doubt that you can have in this case. I submit to you that after you consider the evidence in this case, which included the testimony of Special Agent Hargrove and the testimony of the toxicologist, Ms. Parker, and the evidence of intoxication that included the testimony that he had slurred speech, odor of alcohol, bloodshot eyes, his admission to drinking. You heard Trooper Hargrove say that, you know, it's not uncommon for people to report the amount of alcohol that they consume, and also the empty bottle. And again, not to mention the accident here, ladies and gentlemen, you have more than enough, more than just the blood alcohol analysis. You have more than enough time to defend guilty. Again, it's not an indictment against his whether or not he's a good person or not. It is your oath that you took as jurors to hold people accountable. That's all I'm asking you to do. If you believe we've been our burden to hold this defendant accountable, because our system of justice demands that everyone be treated the same. In our case, we're asking that you find us guilty. I'll remind you briefly of the definition of intoxication. It's listed in your jury charge, but loss of either the normal use of mental faculties or the normal use of the physical faculties, or alternatively having a blood alcohol concentration of 0.08 or greater. Two of you can agree that the defendant has lost the use of his mental faculties. Two of you can agree that he's lost the use of his physical faculties, and still two of you can agree that he is over the 0.08 or whatever.
No, that's outside the record of him being a 0.08, because that relates to the time that he was operating the vehicle, not the time of the analysis. So that's outside the record.
Yeah, just to stay.
Two of you can agree that he had a blood alcohol concentration greater than, and the two of, and
So I would object to the state referencing the 0.08 standard as being outside the record. There's no evidence proffered as far as the blood test analysis being at the time you operated the vehicle as charged. It's at the time of the analysis that they've alleged a statutory violation of the blood alcohol concentration. 0.08 relates to what he was at the time that he operated the vehicle, not at the time of the analysis. The state's presented evidence that what it was at the time of the analysis as pertains to the charged offense. So any argument regarding the 0.08 standard is outside of the record.
Judge, in my statement to the jury, I simply said that they can believe that he had a 0.08 or greater. I didn't limit it to at the time of driving or at the time of the analysis.
Okay, objection overruled. You may proceed.
All right, so we were talking about the definition of intoxication, and what I was getting at is that you do not all have to have a unanimous agreement on the method or the means of intoxication. In other words, two of you can agree that he had a blood alcohol concentration greater than 0.08, or two of you can agree that he had the loss of his mental faculties, or two of you can agree that the loss of his physical faculties. But nevertheless, you don't have to come to a unanimous agreement as it relates to the method or the means of intoxication, if that makes sense. So I didn't want you to think, be back and think that you all have unanimously agree on how he was intoxicated, just that he was intoxicated under the law. Now, Mr. Kim talked a little bit about the test, and he drilled down quite a bit about the gas and all this other business chromatology. Here's the bottom line is either you have faith in the testimony of the toxicologist Smith Parker, faith in the test that's used day in and day out across the state across the nation, or you don't. But I submit to you that even if you throw out that test, your common sense should still prevail in this case. And Mr. Kilmer was correct in that I used to say, you don't leave your common sense at the door. You apply your common sense to the facts and the evidence in this case. I don't say you don't leave it at the door anymore because it's kind of got to stay on the defense attorneys picked up on that. Here's what I do say is I quote a line from a song of mine, a favorite song of mine by Lee Bryce. And Lee Bryce says in that song that don't outsmart your common sense. Okay, I mean, just because we're in here, we're using legal terms and we've got all this legalese. Again, you view this evidence through the prism of your everyday experiences and your common sense. I've seen and I've been made aware of instances where jurors will get back there and they will essentially, for lack of a better term, outsmart the common sense. And I'm asking you again, view the evidence in the testimony case through the prism of your common sense. Again, what a great system we have, that we just don't find somebody guilty because the arresting officer says they're guilty or the prosecutor says they're guilty. This is the way the system is supposed to work. Our evidence has been tested. Our burden has been met. I'm asking you to find this defendant, Cody James Patterson, guilty of the offense of drama intoxicated, not because of what I say, because people are wrong, but that's what the evidence is. It demands that you be held accountable. And I'm asking you to do just that. Hold this defendant accountable. Thank you.
Okay, ladies and gentlemen of the jury, the state has finished closing arguments, defense has finished closing argument. I'm going to hand this charge to our bailiff. Okay, ladies and gentlemen of the jury, please follow the bailiff into the jury room so that you can start your deliberations. And if everyone please stand. The court stands in recess until the jury reaches verdict.
I think it's a lesson.
I'll get the two of you on there.
Yeah, I need to read some case law.
Yeah. What do you think? You think?
I-
I mean, it's different. But it's
You got all your exhibits, right?
Yeah,
And don't forget that's one of them too.
yeah.
We're talking, there's no time, you said that, he said the race and it's.
There's a case that kind of speaks to that.
I think we got to the right result. When Jimmy came down and said the statement, I think
There's a case, yeah,
we got to the right
Yeah.
result.
Like one way it's crazy, like here it's saying.
there's a,
For the one fact, with the Benson element, if that's construed as